you just begin by saying who you are and the organisation you're representing?
Yes, I'm Isabel Thompson. I'm from the National Approved Letting Scheme.
And David Cox from our Property Mark, the Association of Residential Letting Agents.
Thank you for coming. One thing that we've been trying to explore is the quite complicated nature of the laws and regulations which cover the whole issue of the private rent sector. And indeed, from a landlord point of view, the laws that they have to abide by, or from a local authority sector point of view, in the sector, the rules and regulations they're trying to enforce. Do you think there needs to be a complete overhaul of the laws and regulations affecting the private rented sector?
Yes, the answer is yes. Anecdotally, there's about 150 pieces of legislation and regulations affecting agents and landlords. I think what we've got are all the pieces. It's a bit like a jigsaw, but we haven't actually got the picture. I think we need a coherent framework of regulation. I think it shouldn't be a piecemeal approach. We shouldn't be drip-fed legislation. A worry at the moment is we've got the fee ban coming, we've got mandatory client money protection coming in, and we've also got regulation. What we'd like to see is everything wrapped up in regulation. But a more coherent structure, I think, would be the best for everyone.
I would agree with that entirely. We've got a huge number of laws governing pretty much every aspect of renting out a property. They're wildly varied. They've got multiple different enforcing bodies that are supposed to be going out to do it. And nobody really knows they exist. Landlords don't know, tenants don't know, agents struggle. Even enforcing officers themselves don't necessarily understand half the laws that actually govern the industry. And this is the problem of successive governments over the last 20 years, trying to find individual legislative solutions to specific problems rather than looking at the private rented sector as a whole. This is not one government, I would add. This is every colour of government over the last 20 years hasn't looked at the sector in a coherent, in a strategic fashion. And they've just passed law after law after law, and none of it is being enforced. However much people and the witnesses beforehand were saying that they were, they're not. They are 2 local authorities out of hundreds, and the vast majority do absolutely nothing. And we need a strategic approach to the sector. We haven't had a strategic approach to the sector in decades because it has been a very small sector. It has grown very rapidly over the last few years, and government particularly and local authorities have been struggling to keep up and how to deal with it. And instead of taking a strategic approach, they have very much taken a piecemeal approach.
Helen.
Thank you. Since the 1st of October 2014, it's been a legal requirement for all letting agents in England to belong to one of 3 government-approved redress schemes. How effective have these been?
I think they've been quite positive. It is a step forward. Both our organisations have had that as a requirement of membership for many years before the law came into force. So we were pleased it was a step forward in the road to a more regulated industry. But I think there is more that can be done. At the moment, only one of the 3 schemes has a code of practice. The other 2, we don't actually know how they adjudicate and make their decisions. The Property Ombudsman adjudicates against the TPO code, and I think that is something that we really need to look at. And in the context of the redress schemes, we have multiple codes of practice in the sector. We have, as the statutory code, the 2002 rent-only code that is so woefully out of date it's completely unenforceable. We then have the Property Ombudsman's code, we have the PRS code prepared by DCLG, we have the RICS Blue Book. ALA had its own code until 2014 when it got rid of it in favour of trying to condense the number of codes. We very much believe there should be one code, overarching, that the entire industry must comply with and that should be set by a regulator. And until we get that sort of thing, we are going to continue having the sort of problems that have been described in the previous session.
Yes, I think the redress schemes do a good job. I think when the only issue is tenants actually identifying which redress scheme an agent is part of, that can be a difficulty. So therefore, we'd welcome the statement by the government to introduce a single ombudsman or redress scheme. The only worry there would be if one scheme has a monopoly, does that drive up costs? For agents, we would want to see that as a low-cost option. There is the concern also with the tenant fee ban, whether there will be a disconnect with the tenant being able to make a complaint because they're not actually paying for service. But in the main, I think they do a good job.
Thank you. Does the power imbalance between tenants and landlords and letting agents make raising complaints difficult, in your view?
Sorry, to the redress schemes?
No, the power imbalance that exists between landlords and tenants, does that make it difficult for tenants to raise complaints?
No, I don't think it does. I would actually say that the balance is about right between landlord rights and tenant rights. We've seen a lot of laws passed over the last few years, and I would also disagree with statements that have been made to this committee that tenants don't go forward and take cases to court. We know that is simply not true by just looking at the tenancy deposit protection situation 10 years after it came into force. There was a huge case, Superstrike versus Rodriguez, a tenant taking a landlord to court, which went all the way to the Supreme Court, reversed the spirit of the 2004 Housing Act that required this House, and I recall this committee, to have to actually reverse the law back to the original position in the Housing Act 2004. So the argument that tenants don't take cases to court is simply not made out when Parliament has had to restate the law on something because of a tenant taking a landlord to court.
Yes, I don't think there is an imbalance. I think the fact that the Property Ombudsman Scheme's last annual report reported a 32% rise in complaints didn't necessarily mean that service was worse or conditions were worse, but actually tenants were finding and landlords were finding their voice. So I don't think there is an imbalance.
Okay. So, just to push back on that a little bit, this committee has heard evidence from several organisations representing tenants about the very low expectations that tenants have, about the extent to which many feel they put themselves at risk and their tenancy at risk if they raise complaints, and about the poor quality of a certain segment within the private rented sector. Do you have comments to make on those?
It's about a certain percentage of the private rented sector, and I think the whole sector is being tarnished by the criminal actions of a tiny minority. We will certainly not sit here as representatives of the industry and say every agent, every landlord is professional. There is a criminal element in the sector, and that is what we need to tackle. And blanket pieces of legislation doesn't work, never has worked. So what we need is to target that sort of work.
That wasn't the evidence we heard from Shelter. Shelter said that there are a small number of, comparatively speaking, a small proportion of criminally rogue landlords, but there is also a kind of a spectrum and a huge grey area that is about landlords who are in some cases inexperienced, in some cases don't know their responsibilities under the law, in some cases don't have become landlords incidentally, but a whole range of reasons that lead to poor quality, and that within that tenants very many tenants don't feel that they have sufficient power in that relationship to make a complaint and to know that their complaint will be dealt with without adverse consequences for themselves.
But I think that is a question of tenant education and tenant empowerment rather than a lack of law. The same arguments have been made about social housing tenants fearing eviction when social housing landlords have no ability to have the no-fault possession that private landlords have. We have protections from illegal eviction. We have protections from retaliatory eviction. We have housing standards. And the problem isn't a lack of law, it is a lack of enforcing the law. Parliament passes law after law after law in this sector, but none of it is being enforced. And passing another law to cover the same issue that a law already exists isn't going to improve the situation. What we need is much greater tenant empowerment. What we need is a more effective court system. What we need is a more effective enforcement regime, and we need a simplification. The previous panellists were talking about the housing health and safety rating system. Whilst theoretically perfect, practically impossible to implement. We support Karen Buck's bill because it makes it a lot simpler for tenants. But you can have two local authority officers from the same council come and do an HHSRS inspection on the same property. You'll get two different results because it is so complicated, and that is the problem. It's not a lack of law, it's a lack of understanding and a lack of enforcement.
Yes, I don't think I've got anything really to add to what David said.
In October last year, the government issued a call for evidence on whether all letting and managing agents should be regulated in order to practice. What model of regulation should the government follow?
Well, we want to see an independent regulator, and sitting under the independent regulator, we would like to see approved bodies, naturally, such as Arla and NALS, but we would be responsible for the accreditation criteria. And we'd want to see a cross-sectoral code of practice as well. I think it's an overarching regulatory framework that we would be looking at.
I would agree entirely. The model that Isabel has just outlined is very similar to the way the legal profession is regulated through the Legal Services Board that approves, in the legal profession they call them approved bodies, I do believe, of things like the Law Society, the Bar Council, that then regulates the individuals on the ground. Because what we don't want to see, and what we have seen, is a recreation of, one, functions that already exist, and two, it becoming a massive bureaucracy. If we look to Rent Smart Wales, where they have instituted regulation of letting agents and landlords, it has been running since the 23rd of November 2015. Last week they published their statistics that they've done 15 prosecutions in that time, when they estimate 177,000 rented properties. 15, because they are spending all their time on administering the schemes, the bureaucracy of the schemes, rather than actually getting on and doing what they need to do, which is the statutory enforcement of the rules. So I agree entirely with what Isabel has said. Take the admin and give it to somebody else. And with the best will in the world, our bodies have been doing that admin for this industry for the best part of 30 years. We know what we're doing, we know what we need to do, we actually check pieces of information. I am aware with things like Rent Smart Wales, where they have to upload documents. Agents have been uploading utility bills just to see whether or not they actually they get checked, and they aren't being checked. So what is the point in actually creating a bureaucracy if you're not going to do what the organisations are already doing themselves? I think the Scottish Government has learnt that particular lesson with the regulation that comes into force on Wednesday, but I think England can still learn lessons and make a better system for England than exists in either Wales or Scotland.
Okay. And this is just our view. NALS operates what's called the Fair Fees Forum, and we had a regulation subgroup of that forum. The forum comprises tenant, landlord and agent organisations, as well as some of the major letting agents. And we had this discussion about regulation within that group, and they were unanimous in wanting this framework.
Okay, thank you.
Yes.
Yeah, so you will have heard the previous panellists talking about this issue and suggesting there should be a formal licensing scheme. What are your views on that?
Licensing doesn't work. Licensing has never worked and never will work. If we take the rhetoric out of what the three people have just said that came before you, Newham have done 1,200 prosecutions, or 240 a year, out of 47,000 properties. That's 0.5% of the properties in their area that they've actually done anything about, and they've actually done prosecutions. And I would note that that's with 140 officers, 40 police officers, 100 enforcement officers, and they've done 240 prosecutions a year. That's less than 2 prosecutions an officer. If that is what is classed as success, and it is classed across the industry as the most successful licensing scheme in the country, and really, what does that say? It's pitiful. And bear in mind, I agree with Sir Robin when he said that that is 60% of the prosecutions in London and 50% of the prosecutions in the entire country. So in the entire country, we've done less than 500 prosecutions in the year. Take out Newham, the other 32 boroughs have done 160. Is that success? Is that a measuring success? Councillor Newman said that they'd licensed 30,000 properties and refused 10. So is he really suggesting that in Croydon there are only 0.03% of properties that are not up to standard? This is not success. We're the best one in the world. It is a catastrophic failure, and it is a litany of catastrophic failures. Everywhere licensing has been created. The Housing Act 2004 requires licensing schemes to lead to an elimination of the problem. If they have to redesignate the scheme 5 years later, it clearly hasn't achieved its aims because it hasn't led to an elimination of the problem. Getting a landlord to get a piece of paper from the council when they're not going and doing the checking, they're not going and doing the prosecutions, all they're doing is pouring catastrophically large amounts of public money into administration and bureaucracy. Just as Councillor Blackburn said, the schemes cost the government, the councils, a lot more than they generate. I do agree with that. I do believe that is true. At which point they are diverting council resources for prosecution into administration. How on earth is that benefiting man nor beast? It does not work, it never works, it never will work. Rolling it out further is just going to make the situation vastly, vastly worse. What we need is education. Landlords need to be trained in what they need to do. Agents need to be trained in what they need to do. Filling in a piece of paper and giving it to the council and paying £500 is not going to teach them the 150 laws that they need to understand. And therefore rolling it out will be the biggest backward step in improving conditions in the private rented sector in the last 20 years.
Okay, do you want to add anything?
Well, follow that.
Sorry.
Tempting as it is to go down this path, I don't think we have time.
Generally speaking, in terms of relationships between letting agents and councils, does it work well in most areas?
In most areas, councils will have landlord forums which agents are part of. They will have joint initiatives where in licensing schemes they offer discounts to agents who are part of accreditation schemes or trade associations. I think in the main they work well. An example of good working, I would say, is Liverpool, where there's blanket licensing, and both NALS and Arla are what are termed as co-regulators with Liverpool City Council. And that is a good model. Agents who meet the standards to be part of our organisations are rewarded, and their landlords are rewarded with discounts on licensing fees. I think partnership working is always to be praised, and yes, I think that's all I have to say.
Again, I would agree with everything that Isabel has just said. Where local authorities and the industry work together, we get a much better approach to dealing with the issues of the industry. Liverpool is a prime example. Homestamp in the West Midlands is another good example of where fire service, the police service, the health service, local authorities, the landlord, the agent bodies all come together to look at the issues in their area and come up with holistic, cross-departmental working to find solutions. It's probably why the West Midlands has the lowest level of licensing of anywhere in the country, because they have taken a different approach. I would also say the London Rental Standard, created by Boris Johnson when he was the mayor, was a great model for regulating the industry. Again, both Arla and NALS were supportive. We were involved in its creation and its development, its ongoing existence before it was scrapped last year. The problem with it, though, was it was voluntary. If the mayor had had the powers to make it mandatory, and we are now talking about a system and a model very similar to the LRS at DCLG or MHCLG, it could have worked, it could have been much more effective than it actually was. But once again, it's back to, whilst it was voluntary, it was never going to pick up the people that it was designed to pick up.
And some who have been talking about Newham have developed a system for actually rating letting agents, giving you a score. Do you support such initiatives?
We were actually involved in its creation, and we were assisting some of the local authority officers that were developing it in what should go in the criteria for the various levels. It is a good initiative, but it's one of those, if it's at an individual local authority level, we could end up with hundreds of different schemes, which all will have different criteria. It will make it a nightmare for agents to actually comply with all the various things. It's the same problem with licensing. So if there is a coherent national model, I think we would be quite supportive. Even if it was done at, for example, a pan-London level or a pan-region level, we would be quite supportive. But doing it at an individual local authority level is so difficult for agencies that are operating across local authority boundary in order to comply with all the various different criteria that each local authority set, be it a licensing scheme or a rating system such as this. It would need consistency across geographical areas.
Even if you had a national scheme, if individual local authorities are making the judgments, they could still come to different judgments about the same letting agent, couldn't they?
Exactly, at which point a single agent, if they were operating in 5 local authorities, could end up with 5 different ratings. Now that doesn't benefit anybody.
Right. Okay, Mark.
Thank you, Chairman. I think we're crystal clear on licensing schemes, but let me look at the draft tenant fees bill and the impact on your members. There's been lots of discussion and some evidence that's quite contradictory, but from your point of view, to what extent would your members be able either to absorb the costs, and what other impacts might there be in terms of how services will be delivered? In particular, what do you think the likely impact will be in terms of rents?
Well, taking rents, first of all, I think it's obviously the government is always talking about unintended consequences. I think there are inevitable conclusions. If the cost of services is passed on to landlords, they have to recover their money from somewhere. So it has to be, rents are increased, which is very concerning. And we will come on to the impact assessment that the government has made of any increase in rents. We've done a little bit of a survey with one of the major referencing companies, and out of 250,000 references, 25% of the tenants who passed were marginal in terms of affordability. So it is a real concern for us. In terms of service, we obviously hear perhaps from tenant lobbying groups, rip-off agents, and all they're concerned about is money. I can assure you that our firms, the majority of whom are small businesses, they pride themselves on the service that they offer to their tenants, and they go above and beyond. And with the tenant fee ban, that service will have to be diluted, if not disappear, as well as getting rid of staff. They won't be able to sustain their business because not all of it can all the service levels can just be passed in a charge to landlords. So it is really serious for our firms, but it's also for tenants. We do worry about certain categories of tenants who will not be well served by this ban, and those will be tenants on housing benefit or universal credit. You can imagine if agents have less time to deal with these tenants and they're not getting paid, tenants will be screened out, and that is a real worry as well.
Again, I would agree with everything that Isabel's just said. Last year we commissioned Capital Economics to undertake an economic impact assessment on the ban. They came back, letting agent fees represent about 20% of the turnover of the industry, about £700 million a year. In the most plausible situation, and at that point in time we didn't know what the legislation was going to be, the most plausible situation is the ban, the bill as it is currently stands. Agents will lose about 200 million a year in income. Capital Economics estimate that about 4,000 people will lose their jobs in the industry as a result of that. Landlords will see an increase in costs of around £300 million a year, and tenants will see an increased rent of £103 per tenant per year, which means that if tenants move more regularly, they will see a saving. But we have government policy, party political policy, arguing for longer term tenures at this point in time. At £103 per year, the over-under is just under 2.5 years, and therefore, if tenants stay in their properties for more than 2.5 years, they will end up paying more than if fees hadn't been banned at all. We're already seeing consolidation in the industry, smaller agencies selling up to the larger corporates and getting out before the ban hits. We also have to factor in, once the ban comes into force, agents going bust, agents propping up their businesses that can't cope with a fee ban by taking their clients' money, that's their landlord's rent, and their tenants' deposits. So I would strongly urge the committee, the government, to make sure that the mandatory client money protection that is under the Housing and Planning Act last year comes into force before the fee ban does, because otherwise we may end up in the situation where agents go bust running off with the funds before mandatory CMP comes into force. So it needs to be done first.
And just on rent, we have heard evidence that suggests many tenants would prefer to have the cost knitted into the rent. They know where it is, it's easier to budget and so on and so forth. Can I just get your perspective of that, whether that's, you talked about affordability particularly, what is your perspective about, I mean, you clearly understand, or clearly have said that you expect the rents to rise, and actually that's been the evidence we've heard from elsewhere. What's the argument about actually, by removing the upfront costs, the ability for people to be able to access the right home is actually easier, even though the total cost will be spread over the whole term?
Well, I think it's as David said, they will end up paying more than they would if they paid the one-off fee at the beginning of the tenancy. But it's about certain groups of tenants actually getting into tenancies to start with. And is it not better to pay, our average fee is £192 amongst our firms, to pay that to start with, to enter into a stable tenancy, having had a reference check that has looked at your affordability, rather than just having the money added on to the rent for the duration of the tenancy.
Just briefly, and then I'll come on to one last point, but before that, I think quite a few people would say, well, if the service is being provided by the agent on behalf of the client, I mean, we've seen evidence that people are being charged, both the tenant and the landlord are being charged for the same service. Is that something that you recognise that happens in the industry? Presumably it's not permissible under your own codes at the moment.
Letting fees cover three key aspects. They cover the referencing, contract negotiation, and then the inventory, effectively. Each party pays their share towards it. If you think when you're buying a house, referencing is akin to the mortgage application fee, contract negotiation would be akin to the conveyancing, and the inventory would be akin to the survey. The only difference between buying and renting, because in both cases you're taking a legal interest in land, is that when you're letting, you pay it all to the letting agent. When you're buying, you pay it to three different parties, and you generally pay significantly more. Letting agents act in a quasi-legal capacity for the tenant, and because they are taking money from both the landlord and the tenant, they do become the servant of both masters. They owe legal duty to both masters, to both the landlord and the tenant. I'm worried that if this law says that an agent is only serving the landlord, what is the tenant going to do if they want a pet clause, they want a break clause? If the agent has no duty of care to that tenant, if you don't like it, you either sign here, go and get a solicitor who will charge a lot more than Arla's average fee is £202 per tenant, which we consider for the 8 hours on average it takes to actually do the work involved in setting up a tenancy. I think £202 is actually quite a reasonable sum of money for the amount that is involved. And particularly when you look at low-income and vulnerable tenants, benefit applications, one of the things that haven't been included in the government's assessment of impact is the impact on housing benefit. At the moment, housing benefit and universal credit doesn't cover tenant fees. If those got rolled into the rent, that means the housing benefit budget is going to go up because it will start including the tenant fee element. And these forms are very complicated to fill out at times. A lot of letting agents will sit there with the tenant, helping them fill in the application forms for the benefits that they're entitled to. If they can't charge for those services, are they going to continue doing that further down the line? And therefore, I would argue that this is actually going to, again, put consumer rights back for tenants rather than enhance them.
Might just also be worth mentioning right to rent checks.
Mm-hmm.
Agents help prospective tenants with complex right to rent checks, and they take the time to do that. That will not be happening once the fee ban comes in, and that is consumer detriment.
Mm-hmm.
And agents have expressed their sorrow that they will not be able to do that. Also, where you have tenants who require guarantors, the landlord is going to be paying for the reference. Will they then have to pay for a guarantor? I don't think that will happen.
Just lastly, on the impact assessment, you mentioned already, Mr. Cox, that the government's impact assessment as it stands is incomplete. What is missing that we ought to be aware of?
It's an interesting document. I suppose I would note certain parts of it have been lifted almost verbatim out of the Capital Economics report from last year, except the finances, and they have come up with a different impact on agencies, on the industry. It's almost 50% less than the assessment Capital Economics came out with in April last year. The one point that particularly irks me in it is the familiarisation costs, where they suggest that letting agents will be able to completely amend their business models in 20 hours. This is a fundamental shift in the way the industry operates. And I must say I actually found it quite insulting that it was suggested that agencies would be able to just upshift and start again with just 20 hours familiarisation. Some of the large corporates have already spent thousands of hours trying to work out how they are going to react to this. I do think in certain parts of their mathematical calculation are woefully inadequate.
I mean, there are already letting agents who don't charge fees to tenants, including some in my constituency. So, I mean, it clearly isn't the case that this model results in total calamity for all of those agents. Some of them are choosing to do it already. So, I mean, I just wondered if you might comment on that in the extent to which you have evidence from your members who have already chosen to run their business model on the basis that they have one client and they will charge fees from that one client, and as part of the service of providing the service of finding tenants for their client, go on providing other services that tenants interact with, and that business model works for them because they still attract those clients as landlords, and they still clearly are providing an attractive offer to tenants.
You're absolutely right. There are agencies that do offer zero fees to tenants. You generally find that those agencies are at the top and higher end of the market. They are charging higher rents than other areas. Generally, the properties are also nicer, of much better standard, and it is because tenants are willing to pay extra in rent than they are in other parts of the market. The prime example is the build-to-rent sector. The vast majority of the build-to-rent sector, I know it's not large at this point in time, but they generally don't charge fees. However, they charge much higher rents than equivalent size and quality properties in the locality. And actually I would suggest that those sort of agencies demonstrate exactly what is going to happen going forward, that they don't charge fees, they just charge higher rent.
Okay, yes. Do you think there are any loopholes or unintended consequences of the draft bill?
Well, I think we've already mentioned the redress and the disconnect in the service now between the tenant and the agent. I don't think there's anything else that I wanted to add. You've probably got a list.
I've got three. First one that I would raise is the Green Deal. When Scotland banned its fees in 2012, it specifically made an exclusion for Green Deal charges. Green Deal charge is a non-optional charge for facilitating the granting of the tenancy. The tenant has to accept the Green Deal charge in order to be granted the tenancy under the Disclosure and Acknowledgement Regulation. This is particularly important when we factor in that the energy efficiency minimum standards come into force in April this year, and landlords will have taken Green Deal loans out and Green Deal finance out on the properties. It's something we have raised to DCLG, but we would ask that there is a specific exclusion for Green Deal finance built in England in the same way that there is in Scotland. Second one is when a tenant wants to leave a tenancy early. And this one particularly comes down to the tenant default fees issue, which I'm sure we'll discuss in slightly more detail further later in the session. But the surrender of tenancy, we're trying to make sure that there aren't loopholes in this bill. And what I'm worried about is actually the super strike case happening again as a result of this. That on the face of the bill, the tenant default fees clause will allow, if a tenant leaves the property early, wants to end their tenancy before their contracted term comes to an end. It's routine at the moment that agents will charge a fee for that if the tenant wants to get out early, in exactly the same way that every other industry charges a fee, be it a mortgage, a hire purchase agreement, a car loan, even your mobile phone contract. If you want to get out of that early, you have to pay a fee. Your utility bills are another example. But what I'm worried about is a court may in 5 or 10 years' time hold that those fees are unlawful, in exactly the same way as happened with tenancy deposit protection, which will reverse the law and could end up bankrupting agencies. So what we would ask is that it is put specifically on the face of the bill whether getting out of the contract early and getting out of your tenancy early is acceptable or not. We would strongly argue that it should be acceptable, but what I'm trying to avoid is a PPI moment in the property industry in 5 or 10 years' time, and we would like certainty particularly on that issue. The other issue goes to a similar sort of avoiding PPI situation in a few years' time, and that is the deposit replacement insurance scheme. These are emerging into the market at the moment, where tenants pay generally around a week's rent in lieu of a deposit, and it's an insurance product. Now, again, under the bill, that is a non-optional fee for facilitating the granting of a tenancy, so technically is caught by the bill. Some of the schemes have had reassurance from DCLG that because it's optional, they can choose to take a deposit replacement insurance scheme, or they can choose to pay a 6-week deposit, then that won't fall foul within the provisions of the bill. However, it doesn't actually say that anywhere in the bill, and again, asking for legislative certainty on that particular topic. And also with these deposit replacement insurance schemes, they're an insurance product, so they have to pay a renewal premium, at which point that becomes a non-optional premium for facilitating the renewal or continuance of a tenancy, which also falls foul of the bill. And therefore, to avoid lengthy, expensive court cases in 5 or 10 years' time, I would request that both ending tenancies early and deposit replacement insurance schemes are noted somewhere on the bill to give agents legislative certainty.
Okay. Yeah.
Yeah. So, talking about default fees then, should there be restrictions on what can be considered a default fee?
Yes, we'd like to see an extension of permitted payments to include tenant referencing, to include guarantor referencing as well.
Right.
I would agree with that one. I think it's an interesting one, having listened to the evidence sessions that have come before. Other witnesses have told you of the plethora of things that could be added onto the tenancy and put into the tenancy agreement. However, I would note that neither in the written submissions nor the oral evidence that you've heard has anybody been able to give you an example of that. The example that the government used is the example that we have used as well, of things like if you lock yourself out at 2 o'clock in the morning, we will charge you a fee to come and let you in. Now, I think that is actually a reasonable charge if somebody has got to get out of bed at 2 o'clock in the morning, drive to the office, pick up the keys, drive to the property, let the tenant in, drive back to the office, drop the keys off, drive back home, go to bed. I would suggest that that is a reasonable fee that should be allowed. And think about the tenant, that if those sort of fees do get banned, will the agent do all of that, or will they just say my office hours are 9 to 5 please come in during office hours, and then where does the person sleep overnight if they're locked out of their property? What I would also say on that is that clauses in tenancy agreements are already covered by not one but 5 different sets of law. Under the Unfair Contract Terms Act, if an agent or a landlord puts an unfair term in the contract, it's completely unenforceable. Up to from 1977 was reinforced by the Unfair Terms and Consumer Contracts Regulations in 1999. It was then reinforced further by the Consumer Protection for Unfair Trading Regulations in 2008. That was then specifically clarified for letting agents in the property industry in the CPR guidance in 2014, and then further protections were added under the Consumer Rights Act of 2015. There is not a lack of law in this area, and do we really need to create a 6th piece of legislation governing the same issue?
So I'm not quite clear. Are you suggesting there is a need to be clearer, or that it's fine as it is?
I would suggest it's absolutely fine as it is. Again, I agree with Isabel that I think excluding referencing will be a lot much more helpful to the industry and to tenants and landlords to avoid a lot of the unintended consequences that we are expecting from this legislation. But on the face of it, I think it's actually a very sensible clause and doesn't really need to be amended at all.
Okay. So I want to ask about the obligations about reference checks, and I think in a press release, Arla, Mr. Cox, you described failed reference checks as grounds for not returning holding deposits, and does Arla accept that that's not right at this stage?
No, that's actually my understanding of the legislation and of the reasons for withholding the holding deposit. If the tenant has provided false or misleading information, it can be withheld. If that's not the case, I would suggest that greater clarity is required on the face of the bill.
So you feel quite clear about those statements that you've made being correct?
Certainly that is our understanding and reading of the bill.
Right, because we've heard from a number of other witnesses that actually there is quite a lot of uncertainty about that. Would you agree that needs to be clarified then?
I would say that we do need the precise meaning of that clause, provides false or misleading information. If I could just read this out because it is quite complicated. In our view, the issue is tied in with referencing. It needs to be clarified if a prospective tenant provides correct information to the agent but is not granted the tenancy because they are failed by whoever is commissioned to carry out the referencing process, there should be no deduction from the holding deposit. But if a prospective tenant provides false or misleading information to the agent and is not granted the tenancy because they are failed by whoever is commissioned to carry out the referencing process, they should lose or incur a deduction from their deposit. Does that make sense?
Yeah, I mean, I hear what you're saying. It sounds like there's a clear difference on this one, and about how people are interpreting this.
And therefore, I think if there's a disagreement at this stage in the legislative process, I think it's absolutely essential then that it does get clarified going forward, because once again, that's another example of a potential PPI issue for the industry going forward. If some agents take the view that it means if you fail referencing, the holding deposit is forfeit, if a court then holds that is different, agents will have been acting in good faith and could end up causing significant detriment to businesses in the industry. So if that is not the case, then I do think we need clarity on the face of that provision.
Okay, thank you.
Sort of situation where a tenant may believe that they've got a good credit rating, and then there's something comes out that they had a dispute with a mobile phone company 12 months ago over a £10 bill, and that suddenly affected their credit rating, which they didn't realise. Now, it's that sort of situation which surely the tenant shouldn't be penalised for, I think that's, or the prospective tenant.
County court judgments are probably the prime example where tenants may not know that they have county court judgments against them for unpaid bills, for example. And when the referencing agencies do their work, they find out that actually, you've got a county court judgment because you didn't pay your mobile phone bill for 6 months. But that is actually material information. If they didn't pay one bill, what other bills were they not paying that maybe weren't taken to county court? at which point that is both false and misleading information.
But the tenant doesn't know about something, and in good faith, comes with the information, and then it subsequently comes out that actually, for a small disagreement over a bill some time ago, that's affected their credit rating. Does the tenant get penalised for that? I mean, this is the sort of area, I think, which is a bit unclear in terms of the legislation.
Couldn't agree more, and I think that's probably where we do need a little bit further clarity on exactly what those provisions mean, and how they can work in practice.
Right. Okay. Right. Just like to come back to one point finally on your description of the failure of licensing schemes because of the very few prosecutions. Just take you back to Councillor Blackburn, who said that the licensing scheme in Blackpool had over 800 properties in it, the scheme he referred to. Put on one side the prosecutions. He actually said, though, there were over 700 schedules of work came out of that licensing scheme. Then surely that's a success, isn't it? It's not just the prosecutions, but how much work is actually done to improve the properties. Surely that should be a test of whether licensing works, shouldn't it?
Yes, and actually I thought that was really interesting that of 800 properties they did 700 inspections, because that is certainly the exception that proves the rule, I would argue. Okay. But also it was 800 of, I think he said 144,000 properties, which rather small scheme, scheme of things.
Okay, so fair enough. Okay. Right, okay. Thank you very much for coming to give evidence today. Thank you.
The proceeding has ended.